Heavy agenda as always this morning and things. There's a lot of moving parts. Uh, but let me, well, Senator Brock is not here either, huh? Let me pull up my agenda just so I can walk us through that. Uh, excuse me, I think I have a stuffed nose this morning. Um, I'm going to start off going back to the rental registry and code enforcement. And just as an overview there, excuse me, I have to get a tissue. Just as an overview there, this is a bill, obviously, we just heard about it a couple of days ago, that we dealt with over the last 2 years, making progress. But there's always been some connection between code enforcement and the rental registry and the new VHIP program to give incentives to landlords to fix up dilapidated housing. The draft that I think is going to be introduced today, and what David will be walking us through, doesn't do the VHIP piece, though it's fairly likely that at some point those things will get married. But I thought it made sense to, because so much of the VHIP piece is tied up into the appropriations process and part of the governor's spending on his $200 million surplus for 2022 and one-time issues, that I thought I'd deal with those separately. And if there's a marriage to deal there, we'll do that. I think the House is also working on this. Last year we sent something over and they weren't able to get it across the finish line. So I just thought that we would, even if it means we're working on something simultaneously here, I think we both want to see this get accomplished. So there's no harm us working on this as well. And I think we're actually pretty close on a fairly exciting new idea here. So, and then we're going to have some time this morning to deal with the 1099s at the end of the morning. That'll be probably a half hour. And then we'll also have a half hour to deal with our committee's response, which will come in the form of an email or something from me to the Joint Fiscal Committee on the guardrails around accepting the $200 million grant. Help me out here. It's called
the emergency rental assistance
and utility. Right. So we had a joint fiscal committee, or joint fiscal met yesterday, and some of the substantive chairs were there. We gave some input, and they want to make a decision on tomorrow as to how to spend the money. But we'll talk about that some more. I think it's headed towards a solution that it's not ideal, but it's given the hand we're dealt.
Yeah.
So,
Mr. Chair.
Yes.
Can I raise a question?
Yes, go ahead.
It's just that somewhere in the course of what we do and discuss regarding rental assistance, it may not necessarily be the rental registry, but as we talk about the assistance program, I would like to get a better understanding of how rental assistance is provided, to whom it's provided, how it's applied for. I'm particularly getting a lot of correspondences. I think you may have gotten some as well, from landlords who say that it isn't working for them, that they have numbers of people who aren't applying for it, and if they don't apply for it, the landlord doesn't ultimately benefit from it, and that there's a significant problem, particularly at a time in which they're not able to evict. And I think we should spend a little bit of time just understanding whether or not the program is working and how people apply for it and what happens when renters don't apply for it, but landlords have expenses that are continuing.
Okay, we will be talking about that at 11 o'clock this morning. I share your concerns. We're under a time pressure gun. I've asked Josh Hanford to be available again during that period to answer some of those questions, but they're legitimate questions, and they're the kinds of things that in the normal course of things, the legislature would have a significant role to make sure that the program is rolled out in the most effective manner possible. We're compromised because it's the same thing we've been dealing with the last year. We got to get the money out the door right now, and we don't have time for these niceties to be looked at. So, but I share that pain, and we're going to be talking about it, and it will, my guess it'll be reflected in what we share with the Joint Fiscal Committee. But I can say that I think there's a strong desire by the Joint Fiscal Committee to accept at least half of the grant at this point in a general fashion, and then the other half, perhaps more of the money, we would have more time to work on some of the program details to round out the edges. Does that help?
Well, it helps in a way, but to give away what essentially is a large amount of money without understanding whether or not there are any real guardrails is a concern to me. And the question would be, can we accept it in such a way that we still have the ability to put in program modifications down the line on that particular money to ensure that it's being used as intended? And I think that the Fed have an expectation that we will do that.
Right. That's what we will be talking about at 11. And we will have the ability to give input how to design the program going forward. The question would be, even the first tranche of money, how much details can the legislature impose on that first tranche? And in the normal course of things, I'd have real reservations about that. But there's so much money, and there's so much need, and there's so much administrative cost to get the thing going that I see very little chance that we will misspend that initial first tranche, and it has the advantage of getting money out the door quickly. People are hurting right now. There hasn't been mental assistance.
Absolutely. I understand that fully.
And Michael, Sean has something to add here.
I really don't want to. Let's save this for 11 o'clock because we're already backing up. So we're going to go to rental registry and code enforcement, and we're going to hear from David Hall initially to go through the draft that a few of us are sponsoring. It may be released as early today, and again, it doesn't have the VHIP piece on it now. It just has the establishing the rental registry and the movement of the code enforcement from town health officers to the Department of Fire Safety. That's the heart of it. So let's hear from David. Can we put the draft up on the screen? And
is it on our, I don't think it's on our website.
I just posted it.
Oh, thank you, Nathan, or David, whoever just said Nathan.
And David, it wouldn't hurt. You've been very close to this bill over several years now. I want to take a few minutes and just give a sort of a generic layperson description of what this bill is trying to do and fix, and then we can go into the specific sections.
Sure, happy to do that. Good morning, David Hall, Legislative Counsel. I think you should all have showing on your screen, it's 21-887 is a draft 2.1. So as the chair indicated, for a couple of years now, this idea has been percolating, this concept of both in law and in fact, shifting the primary responsibility and authority for rental housing health and safety inspections and enforcements to a quote unquote professionalized state level staff. And you may recall that, in the current framework, I think I spelled out for you in a long memo / amalgamation of statutes a couple of years ago or last year that right now in statute, nominally the Department of Health and by extension, local health boards and local health officers are all charged, vested with authority to inspect and enforce health safety issues related to rental housing. The department has adopted a code that has a pretty extensive framework for all kinds of things from, potable water and functional plumbing and safe electricity and safely constructed and clean and sanitary and all those types of issues that come up in rental housing. And again, each municipality, each town has by statute the authority to have a local health board. Sometimes that is one and the same as its select board, sometimes not. Sometimes there's a professional office like in Burlington, but most places it's comprised of volunteers on the board level and then a local health officer at the town level. Over the years, we've heard that some towns don't actually have or have difficulty keeping local health officials. So the concept was brought forward that to ensure, the availability of safe and sanitary rental housing across the state, rather than have this patchwork of different state and local authority and enforcement, perhaps we should have a dedicated staff either at the Department of Health or perhaps at the Agency of Commerce or perhaps at the Department of Public Safety to have a staff and a specific authority to do this work. And so after a fair amount of discussing who should do what, I think the consensus has arrived that the Department of Public Safety and specifically Division of Fire Safety be vested with this express authority in statute and then in fact be the primary authority responsible for inspection and enforcement of rental housing health and safety, while also preserving local authority to do so if they wish. And as I said, I mentioned Burlington, and the city of Barry has its own program and personnel that to do this work, and they may, if they wish to continue doing so, to do that in cooperation with DPS. So that's the biggest picture view. I mean, this will require obviously first some statutory language to make sure that authority ends up with the correct department and that there's a transition from one to the other. This bill includes the registry of and the registration requirement for rental housing, including both long-term and short-term housing. It authorizes the creation of new positions at DPS and at Department of Housing and Community Development, which have a nominal appropriation to begin the work, and then those are envisioned to be funded through the fees, the registration fees collected year over year. And then, it has some money and effective dates for all of that to happen. So that's the highest level view. Where would you like me to go from here?
I'd just like you to maybe, if you could, say a few words as to why, from what you've observed, why the consensus landed on the Department of Fire Safety.
Fair question. To be honest with you, I have not been in on the meetings where those groups have been doing that work, but I would say that everybody sort of recognizes that fire safety already has about 60-70% of the inspection and enforcement authority for things that might pop up in this realm. And by adding some more words to their statute, they would get the rest. Department of Health has never had the personnel or the sort of full-scale program to do this work, and consequently, it's always been the local authorities who have been the primary parties responsible. So as far as the state level goes, you guys created the Rental Housing Advisory Board. They've done a ton of work on the issue, and they are the ones ultimately working with fire safety who came back with this recommendation.
Okay, that's essentially what I was wanted to get out there. I've heard even as much as 80% that they're in a position to, they're already doing very similar works and have a structure in place where they could take this on. And I think we probably, in our next witness, I want you to go through the bill, but in our next couple of witnesses, Sean Gilpin and Sarah Livingston, the flip side of this is why the existing program is not working and why there is such a need to finally get this done after, I've often said that I've been familiar with this issue for 40 years, back to my original days in Vermont as a lawyer. So let's go through the bill, David, and then we'll get back into witnesses.
Sure. So section 1 here is so we're in Title 20, right? Title 18 is health. That's where a lot of this stuff, or at least, the nominal authority exists, but we're actually going to be amending Title 20 here to add to Division of Fire Safety, public buildings, building codes, rental housing, health and safety. The bit about building energy standards is just to reflect in the subchapter title and in the chapter title previous legislation that has expanded the scope of their authority. There's nothing in this bill that relates specifically to building energy standards. I just want to flag that. It's a descriptor for what's already in the law. The term public building really is sort of the key to how we get fire safety at the table. Public building means a lot of things under this chapter, but it includes places like restaurants and other places, hotels, etc., gathering places, tents, circuses. Commercial buildings, places where the public comes and fire safety issues and safety issues are relevant. It includes here in subdivision D, and it already includes in D, a building in which people rent accommodations, whether overnight or for a longer term. And I'm adding here, including rental housing is defined in subsection F. And that is to specify just further down in this section that when we say rental housing, we mean both housing that's subject to the landlord-tenant laws in Title IX, also short-term rentals that's currently over in Title 18. So you'll notice here that public building does not include owner-occupied single-family residences, as long as they're used as such. Right now, in current law, it wouldn't include, the term public building would not include a single-family residence with an accessory dwelling unit as permitted in Title 24. And by striking this out, we are actually bringing accessory dwelling units into the fold. So they would be subject to fire safety's authority here. As I said before, rental housing, it's both a dwelling unit as defined over in 9 VSA chapter 137, the residential rental agreement chapter, also short-term rentals as defined in Title 18.
So
And
David,
yes,
on this accessory dwelling unit,
yes.
is the intent now to have fire safety have oversight over the accessory dwelling unit only, or the accessory dwelling unit and the private home in which the accessory dwelling unit is located?
Yeah, it's a good question. I think the intent is that if the accessory dwelling unit is being rented then that falls under the jurisdiction. But because of B1, the owner occupied single family residence would not be. I mean, I would, I guess, defer to you and to Mike DeRocher what, ultimately you want to happen, but that's the way I would read it. So that they would not be inspecting single family residences, but they could inspect the accessory dwelling unit component of it.
Okay, we probably, it's not an insignificant issue. We probably should discuss it in committee, what we want to have happen there. Hear from Mike DeRocha at whether, I mean, I can see like electrical systems affecting both the ADU and the underlying house. And how do you distinguish where they issue orders and things like that? So
Sure.
I think it's a fine point, but we need to make it clear whether we want to sweep in the underlying building as well as the ADU. So
I think it's a great point. Yep.
Yeah.
So right now in 2731, already Commissioner of Public Safety has this authority to adopt rules regarding construction, maintenance, prevention of fire and fire hazards, and standards necessary to protect the public. So we would add here health, safety, sanitation, and fitness for habitation of buildings. Those are sort of the four categorical items that are in the current Department of Health rental housing safety code. And to add them here, obviously the intent is to just expressly vest that authority with public safety in their rulemaking powers in subsection A. It's the same with B. I mean, right now they have this authority to inspect premises, which also means public buildings. The new matter in 3, you may recognize from bills passed. And right now, this duty to issue this inspection report is charged to the local health officials in Title 18. So we would import something comparable here so that when fire safety does an investigation of rental housing, they have to issue a written inspection report that has findings of facts. It specifies the requirements to remedy the violation. Notice that you can't rent it until you've corrected it. And then notice in plain language that the landlord and the agents have to have access to the unit to make repairs consistent with 9 VSA 4460. So that section of law over in the landlord tenant chapter is what specifies landlord's ability to access the premises either with notice or to come in for an emergency, etc., between certain hours of the day. So under B, they have to provide a copy of the inspection report to the landlord, the person who requested it, any affected tenants. C, if the whole building is affected, then they have to give this notice either directly to the tenants or posted in this common area with information about the inspection violations, how to get more information, etc. And it specifies here that the inspection report is available as a public record. I included the next few subsections. There aren't real changes here, but I want to flag some issues and raise some questions for everybody to consider. The first one being fees.
David, before you go there,
please.
The sections you just talked about, I just want to have an understanding. Is this developed wholly out of new cloth, or are we taking essentially charges that used to be with town health officers in the Department of Health that haven't really worked and moving them over to fire safety? Or are we moving the population of these rental units and inserting them in fire safety's code?
Sure.
Or something totally new?
Yeah, it's a good point. So the duty to issue a report after an investigation is relatively recent. It's currently over in Title 18, And remember, in Title 18, there's this duality where, the Commissioner of Health, the Board of Health, and the Department of Health, as well as local health authorities, at least by virtue of the statutory language, all have a statutory authority for rental housing, health, and safety. You remember a few years ago in the bill in which you guys actually created the rehab board, one of the things that you articulated that needed to happen was that you needed more information about the scope of inspections, when and where they were occurring, what the kinds of violations were, et cetera. And that information was part of what built the recommendations in subsequent bills. So this piece about inspection reports actually came in a few years ago, added in the health title. Local health inspectors are supposed to be issuing these reports and sending them to the Department of Health, which was aggregating the reports and trying to figure out the scope of the issue. So in that vein, it's not new, but it is migrating to the Division of Fire Safety. So if they pick this up and continue doing investigations and inspections, they will have the same duty to issue reports to people who are affected and to the public.
Okay.
As best I remember. I'm sure there's plenty of people on this call that can know this stuff encyclopedically. So I was going to raise the point about fees. And the reason being, as I was preparing this bill again for this year, it occurred to me that the rental health inspection doesn't fit neatly into any of these categories necessarily. And I guess my question was, which of these fees will they be imposing for the inspections? And I don't know that I ever learned that. And that was an oversight on my part last year. And so I would just flag, for your consideration, which fee is it? I know there's already estimates on how much revenue they're going to take in. So they already have something in mind, but I wanted to flag that. The same with some of these other pieces. I mean, I included this stuff because I want you all to know that it's here. For instance, in E, variances and exemptions, this does give the Commissioner of Public Safety right now the authority to grant a variance or an exemption from rules where strict compliance would entail practical difficulty, unnecessary hardship, et cetera, as long as it doesn't, come at risk of public health and safety, et cetera. So I just want you to know that authority is there, and that would continue and be grafted onto the rental health and safety pieces of their work. Same with 2733 here. I mean, it's a pretty broad authority right now. The Commissioner of Public Safety basically can issue an order to repair, rehabilitate, or even remove a structure if they find it to be, unsafe and a risk of public safety. So you'll see.
Yeah, can I make a suggestion?
Please.
And tell me if this is off base or people have already done this, but it seems like what we're trying to do is fit a service responsibility that has been done fairly effectively by the town health officers or the Department of Health for decades. And we're finding a new home for it. It's going to cost some money in the transition and in ongoing staffing to get it right. But in an effort to fully understand how neatly this uh, program of inspecting rental units coincides or fits into the fire safety functions that the Division of Fire Safety already does. I think it would be helpful for the committee, for you, David, to work with Mike DeRocha, and I'm trying to think, maybe anybody else like Sarah Carpenter, and just go through all these things you're going through now and say, here's what fire safety requires for fire safety right now. And all these things are equally applicable for rental assistance, and we don't have to make any changes. And then also highlight ones where they need tweaks specific to rental assistance because it's different than a fire safety hazard. So when you're talking about these fines or fees and those kinds of things, are they going to say, you know, $125 for the first registration works fine for this as well as it did for fire safety? So just, all the things that we're just assuming fits in nicely. If we could get a memo from primarily Mike DeRocha with your help as to where he said, I could use some adjustments in these areas as I take on this new role. Is that clear?
Yes.
Okay. I think that'll help move us towards finality in this bill.
Mr. Chair,
Yes.
Senator Brock has his hand up.
I'm sorry, I do see you, Senator Brock. Go ahead.
I have a question regarding enforcement and penalties. We flashed by on the screen pretty quickly a series of penalties that could be imposed in the event that the owner of a public building fails to make corrections. Is there the possibility that the owner could simply remove the building from its rental use and therefore no longer become a public building? And what would happen? Is that a potential remedy that the landlord has available to him?
I mean, I don't see why not. I mean, it could obviously violate a lease agreement or something else that, was in effect. But, I suppose if they terminated all their leases and stopped renting the building, then they would no longer be subject to the jurisdiction.
Well, that then raises the other landlord tenant question, that in the event that you have a tenant in a facility and it's deemed to be a hazard from a fire standpoint and repairs are ordered, if the landlord then says, I'm no longer going to rent that property, I'm going to remove it from the public building status, what happens to the tenant who has no lease? Let's assume it's a non-lease tenant. What happens at that point as far as the tenant's rights, if any?
I don't know that it's any different than any other landlord-tenant situation. I mean, if there's no lease, I mean, there has to be some arrangement. It's week to week or month to month or day to day. And obviously our landlord-tenant statutes dictate a timeline by which a landlord has to give notice of termination. And then there's more time before it's effective. And then if they don't leave, you have to go through ejectment. But
So here you can't eject someone because theoretically they've already left in the event that the premise has been ordered because of the violation, that a person can't live there.
We can get more information on this. These become very fact specific. There's been a ton of litigation around these kinds of circumstances where the tenant is effectively evicted because the place is closed down, and what rights does the tenant have in those situations? Which right does the landlord? We have some legal aid attorneys on the case, but I think you'll find out there's probably some creative lawyering going on in those circumstances as to what the rights and responsibilities are. We may want to write something in the statute. We may want to leave it to the common law.
Well, that's what I'm inclined to think, is that the more clarity you have, the better the statute will be. And I'd love to see some clarity in that area.
That we could definitely talk about that some more.
There is a piece just coming up about how they have to provide notice to tenants and if they're going to be affected or displaced by the decision to condemn or, find the place unsafe. So, but yeah, it's complicated.
Well, I mean, the kind of situation I can envision is that you do an inspection, and what the inspection indicates is that a substantial amount of renovation, such as the replacement of the entire electrical system, for example, would be required. And economically, it's simply not feasible for the landlord to make those repairs, given the amount of rent and so on that he or she gets. And the question is, do you force the landlord to do that and go broke, or do you allow the landlord to terminate the lease? And then if so, what happens to the tenant? These are things that I think ought to be clarified, because there's situations that I think are very likely to happen.
I think that's fair. I think the duty to provide a safe premises is already in law. So, I mean, the other wrinkle in your scenario is that even if they got the report, figured out the whole system needed to be upgraded or else, I mean, they're still on the hook for providing a safe premises for their tenants and could still be, penalized or sued for not having done so beforehand. I don't know. I mean, like the chair said, each circumstance would be very fact specific. And then of course there's the overlay of protections from the landlord tenant chapter.
Yeah, I don't mind delving into that, Senator Brock, a little bit. I mean, my past experiences, you get an eviction for non-payment of rent. The tenant says, I'm not paying, I'm withholding my rent because this place needs substantial repairs. The landlord says, if you make me do these repairs, I'm just going to close the business because I can't afford it. Frequently, it winds up in the court, and they wind up reaching a settlement where the repairs get done over a period of time that it can be made affordable, and everybody goes away content with the settlement. Other times it just breaks down. So it becomes really fact specific. We may be getting into landlord tenant law, but you're right to raise that if we're going to be real about enforcing quality housing, we need to have at least an understanding when these situations which are not entirely oddball. It's not just going to be one in a 10,000. There's going to be more cases than that would give some direction of how they should be handled.
But we don't want this to become a relief and protection act for the legal profession.
Oh, yes, we do. Okay. All right, Devin, please continue. I'm sorry.
Sure, no worries. While I'm pulling it back up, I'll just say that, as I said, in current law, there is a implied warranty of habitability that, at least by letter of the law already requires these premises to be in compliance. I understand the reality of the situation, and I think everybody does. And remember that part of the discussion of this bill a couple of versions ago was this concept of carrot and stick. We're going to have more regulation and enforcement. We're also going to have a program akin to VHIP or something like it, where we can try to help landlords bring these places up to code with investments. So that was sort of, and I think it was actually this committee that pointed out that the VHIP as originally proposed would not have allowed that to happen. And then you modified it so that it would allow those infusions of capital to be available to bring code compliant properties into code compliance. So anyway, if you're seeing your screen again, I want to also along that vein of what's already here and whether this meshes well, I want to flag 2736. This is municipal enforcement. Obviously, this relates under current law to the fire safety side and the other authorities that they already have. But this would equally apply now to rental housing, health and safety, at least as it's currently constructed. so that the municipality could continue to have the ability to have its own sort of setup and enforcement framework. You know, under the current law, this does require the approval of the commissioner to be able to do that. So, you know, I think that's a fair question to be posed to fire safety and to towns. Is this current construct in law acceptable to everybody? Everybody with me?
Yeah,
Okay. So the fees that the fire safety collects on this go into that fund, and I guess I kept it here sort of to flag the question of whether there needs to be language in this act that specifies that the fees that what the fee is, what's it called, what's the amount, does it go into that fire safety fund, and then from the fire safety fund do we transfer dollars to DHCD or to DPS for funding the positions and the work that's going to happen down the road? That's all technical stuff we don't need to dwell on right now, but I just sort of had a question about how that money is going to flow and what the fee structure is. You'll see on page 14 here, section 2, we have the rental housing registry. So this is in DHCD. This is in coordination with Fire Safety, Department of Health, E911, and tax. But DHCD is charged with implementing this rental housing registry. So it would create and maintain a registry of the rental housing in the state that would include dwelling units under landlord-tenant law. It would also include short-term rentals as defined in Title 18. Under B, DHCD would require for each unit that's registered all of this data: the name of the landlord, contact info, location of the unit, year built, type, number of units in the building, span number, accessibility, and any other information department deems appropriate. So that's a fair amount of data. And then under C here, upon DHCD's request and at least annually, any local entity that operates its own program and requires a fee would give the same data to the department. So the department would have all the same information from units that are otherwise registered and managed at the local level. 2479 imposes the rental housing registration requirement. It requires that a landlord file with tax the landlord certificate that's required over in Title 32, and then within 30 days of filing that, register with DHCD. The registration fee for the registry is $35 per rental unit, unless you had to register with another program and pay them. So you wouldn't have to pay twice. If you already had to pay Burlington, you wouldn't also have to pay the state. You'd still have to register. And then there's some exceptions here for whether if you're already registered with a department because you have a mobile home and a mobile home park. I don't know that we need to get into all those little details right now. If you fail to register, then it's a late registration fee of $150 and the possibility of an administrative penalty up to $5,000.
Where did the $35 fee, how did the $35 fee get calculated?
The board did that. I don't know their methodology. I would defer to them.
The
Rental
advisor.
Housing Advisory Board.
Okay.
Let's see. So under 4 here, DPS is authorized to create 5 full-time classified inspector positions to conduct health and safety inspections. Under section 5 here, DHCD is authorized to create 1.5 full-time positions to administer and enforce the registry requirements. and 1 full-time position to enforce compliance with registry requirements. So,
So is this envision, is this the normal timeframe, effective on July 1st, with these positions being hired on July 1st and the fee being collected sometime during fiscal year 22?
yeah, we have to look at the effective dates because there's kind of a rollout over when the requirements take place, when people can be hired, when the fee is imposed, how we pay for them. So that's sort of at the end.
Okay,
Section 6, we don't have to spend too much time here. Basically, it just clarifies that this is in Title 18, that local health officers would now have the authority to assist the Division of Fire Safety in inspecting rental housing. Of course, this is what they already do under current law. You'll see here Section 603, which is being repealed. This was the part I referred to earlier about the inspection reports, that duty would now be grafted onto the DPS authority. So there's no, that comes out, and then we have.
I missed
Yeah.
you. I missed something where you said the town health officers can continue to assist. Is that what this proposes, that they still have a role, but it's a secondary role? Can you explain that?
Yes. So we have the local health boards, right? And we have local health officials, and they have statutory authority right now to do this work. Their work is not limited, obviously, to rental housing. There are other public health hazards, health safety measures that may come up that are not just rental housing. And so that authority continues to live on. And because we do have this sort of state local dual authority between Department of Health and local health to enforce the rental housing health and safety codes, the intent, my understanding all along, has been that local health officials and local health boards could continue to play that same role within this system. It would be in partnership with DPS, and we saw above that they could even have their own freestanding program with the approval of DPS. But yes, to answer your question, the local health officials and boards would still have a role to play in this system. Some may choose not to do it. Some may choose to do it. Some may choose to have a freestanding program, but the authority would continue for any of those options. At least that's the way this is.
Sorry, I was muted. Do we make clear in this bill that, I don't know who makes the choice as to how much involvement they have, but regardless of who makes that choice, once that choice is made, is there any communication between fire safety and the town health officers as to who's primarily in charge, who's on backup, when and if they can be called? I mean, have we addressed that issue? I mean, we don't want to come out of this with a confusing situation. That's your job. That's my job. That's both our jobs. We both show up at the house at the same time. Is that taken care of in the bill?
I don't think that the bill addresses that. I mean, I think there's two realities. One, that when fire safety has some sort of cooperative arrangement with a locality, they usually enter into a memorandum of understanding that governs those kinds of terms. Statutorily, they both have the authority. In the real world, my impression is that there's not like a line of people waiting to go inspect properties. And I think this bill is intended to address the opposite problem, which is there isn't enough person power on the ground to even do the job. So primarily, you would be adding 5 new people at DPS to do this work. And I don't know if this bill passes, I don't know what fire safety's outreach to local communities looks like, how they want to pursue quote unquote power sharing arrangements. I don't know what that looks like.
Right. And Mr. Chair, it's Allison.
Yes,
Um,
please.
I think that's an opportunity that we probably need to address with Mike. But given how few of our towns are big enough to have their own programs in place, I think probably every town I represent, practically, with the exception of 1 or 2, would welcome this kind of partnership and working in concert, because many of the issues they're addressing are way beyond their expertise, their training, their abilities to deal with, and they just avoid them. And as a result, we have, sort of situations that have gone on for far too long, not constructively or productively addressed. And this but I think we need to be, depending on how Mike testifies, and maybe Sean on this, we probably need to encourage them to obviously do outreach to all of those towns, and to establish some system of cooperation and clarity about who does what when.
Right. I appreciate everything you said, but I do think that the law itself should have a sentence or
Yeah.
something about a memorandum of understanding or a default position as to responsibility that can be overridden by the department and individual towns if they want to. But you could be dealing with some really serious situations here, deaths,
Yeah.
fires, people falling off railings. And when that happens, it leads to litigation, and people want to point fingers at everybody. And so we can avoid that by not being clearer as to who has the primary responsibility and when and if they've agreed to something different. So I think
Right.
we want to at least give that, say what the default situation is, with the ability for individual towns and fire safety to vary from that.
Yeah, I think that's a good point, and one we should chat about with Mike.
Yeah.
So maybe this next section of the bill would help, frame your thinking on that, because
You mean the transition piece?
yes,
Yeah.
this is
Good
the
point.
piece that sort of talks about how this transfer of authority works. So in section 7 here, under A1, until the Commissioner of Public Safety adopts rules governing rental housing, health and safety pursuant to 20 VSA 2731, the Department of Health, local officials authorized by law, and the Department of Public Safety have concurrent authority to enforce the Vermont Rental Housing Health Code adopted by DOH. Remember, I said at the beginning, there's already this rental housing health code on the books, and right now in statute, DOH and local officials have this dual authority to enforce it. And this would add sort of DPS. They're just all there. I mean, there's a real world, obviously, aspect to them talking to each other, and DPS being in its position and ready to go and start the work. On subdivision 2, the Commissioner of Public Safety may immediately adopt a rule incorporating the code without going through the Administrative Procedures Act. So what that means is that on day 1, if they want to, if they're ready, DPS could just adopt the current code in whole cloth as its own rule. And, as soon as it does that, it would have the Department of Health would be out of the picture, and fire safety would be the primary pursuant to this act. This just, the purpose here is to recognize that there are multiple layers and to try to talk about how that transition of power is going to happen. And as I said, a little bit, that's going to have to be a cooperative conversation among the constituencies. Under 3 here, except as provided in subdivision 2, public safety does have to go through rulemaking if they're going to do something other than the current code, right? So under B, upon this adoption of rules governing rental housing health and safety by DPS pursuant to its authority, under B1, the Department of Public Safety is the state government entity with primary authority to enforce state laws governing rental housing health and safety. Under B2, Department of Public Safety and local officials have concurrent authority to enforce state and local laws governing rental housing health and safety pursuant to, all of these different provisions. And under 3, Department of Health, State Board of Health, local health officials have concurrent authority to enforce state and local laws governing public health hazards and public health risks, as those terms are defined in these various places. So as I said earlier, there's more to the current portfolio and the current statutorily vested authority in DOH and in local health officials and boards. There's more than just rental housing, and that's restaurant safety and mercury poisoning and other things. And once this transition happens, DOH and the local health officials still are the primary people on those issues, and DPS, and could be concurrently, could be through its own program, but primarily DPS is responsible for the rental housing health and safety.
David, in drafting this, did you work with the health department, fire safety, League of Cities and Towns in terms of this whole transition sections and the wording here?
I would guess that they have read this more times than they want to.
And as far as
yes. So it's been a big cooperative process. They have done an incredible amount of work, and I've tried to, reflect everything in language. It's, the process continues, but everybody is certainly aware and has contributed to the development of the concepts and the verbiage.
That's good, because they're going to have to live with, there's a lot of transitions going on here, both in timing and scope, and, it needs the people who are on the ground to give their blessings to these sections. Let's go on to the appropriations.
Sure. So this is really new to this year. Trying to figure out what do we need to get things started versus what will we use and what will we need to keep things going down the road. So you'll see in 8A here, there's an initial $200,000 from the general fund to DHCD as one-time startup funding to assist in creating the rental housing registry. And same in B, $200,000 from the general fund to fire safety for one-time startup funding for the positions, those 5 inspector positions authorized in section 4. You'll see in C, from the amounts collected from rental housing registration fees, finance and management will allocate $200,000 to DHCD to assist in the creation of the registry, and $345,691 to fire safety to assist in funding the positions. I'm just gonna let them speak to the numbers. Obviously, they've done the math, and whether it works is going to be up to you guys. But conceptually, some startup funding and then future funding from fees. So effective dates, you'll see, as I said, there's sort of the staggered rollout. So on passage, the registry would be authorized and created And then DPS rulemaking authority and the transition would take effect. July 1st, the DHCD positions and the appropriation section take effect. That's when the fiscal year starts and there's money coming out of the general fund. So that has to be July the 1st, or it doesn't have to be, but usually that's how we would do it because it's an FY22 expense. Under subsection C, the DPS positions would come online October 1st, and then D, the other sections would take effect on January 1st. So section 1, section 3, the duty to register, and section 6, conforming changes to Department of Health.
Okay. Looks good. Any questions? Before we turn it over to additional witnesses, just want to refresh the committee's attention to one idea that floated around for several years was to put more money in one-time money to jumpstart the inspections for like the first year without charging landlords for that first year to get them accustomed and more of a buy-in into the program. Apparently, at least in St. Johnsbury and maybe in another town, it was started up that way and they had a very good take-up rate and a greater acceptance and less resistance from the landlord to imposing an inspection program in their towns. I think we have a lot of one-time monies available to us, certainly at least relative to past many, many years. And there's a focus on housing. This bill is important. And if that's a sweetener that's necessary, I, for one, think we should take advantage of that sweetener. So we'll talk some more about that. Let's see, can I pull up my agenda here?
Mr. Chair, we can't see you.
Oh, really? I'm sorry. I'm glad you could hear me though, right? Yep.
We can hear you.
Okay. I'm trying to pull up my agenda.
Can you see us?
I can.
Okay, good.
Okay, I've got the agenda. Let's hear, I think, from, we'll circle back to Sean in a little bit. Let's hear from Shayla and then Karen Horn as to their reaction, and also from a town health officer to what they've heard today and in previous days on this bill, which should have a number fairly soon, maybe even today. So Shayla, you want to join us?
Shayla's got a new.
JLo will rejoin us at 10. She had another meeting to attend.
Okay, is Karen Horn with us?
Yes.
Yep.
Senator,
Good morning, Karen. How are you?
I'm well. How are you doing?
Hanging in there. So have you been following this bill fairly closely? I hope?
Well, I'm seeing the draft just this morning, but I've been listening. And 1 second there. Okay, so I'm Karen Horn with the Vermont League of Cities and Towns. I think everybody knows me. And we were participants on the Rental Housing Advisory Board. We supported this kind of legislation last year, and we are supportive generally of it this year, although as I haven't had a chance to actually read the words on the bill yet. But primarily, I think it's important to say that we do support the move to the Division of Fire Safety. And you'll hear from James at least about what it's like to be a local health officer, particularly in a small town in Vermont. It's a volunteer position. We've spent all these years trying to address rental housing issues with volunteers, and some of them are well qualified and some of them don't really have any background in those issues until they acquire the position of local health officer. And as you also know, many times somebody is assigned a position at the local government level because they weren't at the meeting, or they were the last person standing at the meeting. So to take nothing away from the dedication of those folks, I think it would be very helpful to have access to the professional expertise that both the Department of Health and the Division of Fire Safety provide. So as I said, we've supported that move. We've also supported the Registry of Rental Housing Units. We didn't weigh in on what the fee should be. We haven't weighed in on the appropriations section. I guess that's best left to the folks at the administration who do that kind of work. But so I'm happy to answer questions, but at this point, I just wanted you to know that we are supportive and have been supportive of this move for the last several years.
Thank you, Karen. So to the extent this has not been done yet, I'm going to hope that the various players, which I think include the Rental Housing Advisory Board or Council, whatever their name is, has been discussing the various iterations. And I think they have weighed in on a similar bill in the House. And this bill is very similar to the one we've dealt with last session. But to take after today to reconvene in a, however you want to do that, and get us written comments on any questions or concerns you have with this draft. So we'll have it all in one place. I get the sense that there's a lot of collaboration going on around this bill. And I hope that what we get back from this committee is a consensus position and not like 20 different points of differences to how the bill can be improved. It seems like you've worked together great and put forward ideas, and I think most of them are incorporated into this bill. And we do have, I think, maybe Josh or Sean could tell us that, but I know Earhart could, and Wendy could also tell us a little bit about how close people are on this draft and whether there's other fixes that are needed. Let me move on to James from the town health officer perspective, a very challenging job to say the least. Let us hear your experience.
Yeah, thank you, Mr. Chairman. I submitted some written testimony that I won't go into in detail. It's available. I think if there's a distribution system to get it to you. But in essence, what I would say would be that at this point, in the towns that do not have municipal code enforcement structures, that the remaining rental housing stock, which is estimated to be around 50,000 units of rental housing, is being inspected by town health officers. And the biggest problem for a town health officer is, in general, a lack of the technical skills and knowledge and available time just to do the work, a lack of legal skills to take enforcement steps when they're necessary, and the problem in individual towns of not having a budget to cover the cost of any legal work that's required for enforcement purposes or for a more organized inspection activity on the part of the town health officers. I see the communications among the town health officers. A very frequent repetition is regarding how certain technical aspects such as heating and electric should be handled. What are indicators of serious problems, and what to do next when they're uncovered. So I think that what is being proposed in the legislation that you've been discussing this morning is a good step forward to try to put the inspection process under an agency which is already on a professional basis carrying out inspections, knows how to do them, and can add on the rental housing code as part of the work that they do with some additional staffing to carry it out. The initial proposal was for 5 full-time positions. I think that would probably be an initial effort to see whether how far that goes, how sufficient that is. But I think overall the approach that is being proposed here is a good one. And I think the Rental Housing Advisory Board essentially has been trying to drive the process in this direction during the whole time it's been meeting. And I just add one thing that a couple of points to finish up. One, I think the registry is very important in terms of being able to know where the rental housing stock is precisely. In my own town, I mean, I've seen numbers indicating that we have approximately 150 units of rental housing, which is a small number, but I've been an active town health officer and I don't know where most of those units are. So the registry would help with that point. One more thing I would say is that because of COVID, health officers have either been inactive during the past year or simply dropped out of the program entirely because of the danger to their own individual health. I had to make the decision this year because of my own health with an immune compromise to stop doing the work and to not accept any further stipends for the work. So it's with regret that I've passed on from that activity. But I think what's being proposed is the system that we really need in the state to protect that rental housing stock and to protect renters. At this point, they're not being properly protected. And I hope, deeply hope that you'll be able to succeed in what you're working on now.
Thank you very much. Appreciate that. Appreciate your work.
Yeah, you're welcome.
Does anybody have any questions for James?
I do.
Senator Clarkson.
Thanks, James. Thanks a lot for this. Your testimony looks very fulsome, and I sadly haven't had a chance to read it all. I'm just curious what kind of training you actually get as a volunteer health officer, or do we rely on those volunteers being in the medical profession?
Well, I think by and large, the health officers are not in the medical profession. Pardon me, I'm sorry. My own training is I have a background in law enforcement. I'm a licensed attorney. So in terms of looking at enforcement, maybe I'm a little better equipped and skilled to be able to take that on. But the average health officer, I suppose it's fair to say that there is not an average health officer.
Right.
The range of skills is wide and sometimes appropriate, sometimes not appropriate. But the piece that's really missing is the kind of deep technical insight that you gather from doing the work year after year and being carefully trained in how to look at particular systems or problems within the rental housing stock. The training that's provided by the health department is rather general, and it takes place usually twice a year. And it's quite repetitive because very often the health officers who are taking the training are new to the job because there's high turnover within those positions.
Well, that's helpful in and of itself. Yeah, and how many years have you been a health officer in Marshfield?
5 or 6 years.
5 or 6. So maybe not so in Woodstock, before our fire chief took over in a response to our work actually on this, we had a health officer who was in the medical profession, but she had seen a fairly serious change over the last 15 years. Have you noticed in your time a change in the kinds of issues that you're being called in to address and look at?
Well, I guess I would say this about being a health officer, that health officers will deal with dog bites as a routine that occurs over and over and over again. Seems out here in the country, everybody's got a dog, and if there are enough dogs and enough people coming into contact with each other, somebody will get bitten, and the health officer investigates that. Well, that's not a highly technical investigation, but doing an inspection of rental housing is time consuming, it's very detail oriented, and it's got a very heavy technical component that the average health officer is just not going to be sufficiently skilled to take on. The more we can professionalize the function, give it to people who do it for years, who are well supported and well trained to do the work and working within a systemic operation of state government, I think the more likely we are to provide protection of the valuable rental housing stock and the people who live in it.
Right. I've also heard from other towns that I represent that there's that critically important piece, the technical piece, but also the interpersonal and mental health training with many situations that an interfamily dispute. I mean, that there needs to be also some training in the personal management of some of the very challenging situations that they find themselves in, that they again have not the expertise to deal with.
Well, that's a particular concern expressed by many health officers, is just being pulled into what is effectively at the point that the health officer is involved, an adversarial relationship between the renter and the landlord's concerned that whatever the involvement is of the health officer, that it's going to end up costing money.
Right.
And so there's a lot of negotiation, a lot of stress involved for all concerned, but particularly for the health officer who's trying to essentially assume a neutral and helpful relationship with all the parties involved. Not everybody has that skill.
Yeah. Thank you.
You're welcome.
Thank you, James. Just one brief question before we let you go and take a break. We talked a little bit about the fact that the way the bill is drafted may leave some ambiguity as to whether there is a continuing role for town health officers, if this law were enacted, in rental inspections. Do you think that needs some more clarity, or if we gave this primarily over to fire safety and you still had some powers, would that be somewhat confusing to you when you got a call, what you were supposed to do, and yada yada?
No, I appreciate the concern that you and the rest of the committee have raised on this point, but I think that just in terms of the realities, that at least in small communities, there's going to be a great sense of relief that this responsibility is being primarily transferred to the Division of Fire Safety and taken off the shoulders of town officials and particularly town budgets. The towns are not keen to be spending money for this function, and they haven't been.
Right.
Okay. All right, thank you for that.
You're
So
welcome.
we'll take a 10-minute break till 10, and we'll hear from Shayna and from either Josh or Sean, and that should take us to about 10:45, and we'll have about 20 minutes each for the 1099 and for the $200 million rental assistance and utility program discussion that Joint Fiscal Committee wants to hear our opinion on. So we'll see you in about 8 minutes. Thank you.
Karen, if you have to go, but you want me to relay something to the committee, I'm happy to do that unless you're going to stay. I was going to tell Michael he didn't see your hand, but.
Well, I can, thank you. I can put it in written comments also. I just wanted to emphasize the point about towns that have a process in place today and would like to keep that in Burlington, St. Albans, Brattleboro, those kinds of towns are certainly on that front.
Karen, you know what would be helpful? It's Allison. What would be helpful there is getting us how many towns have that in place. I think before you came on, we were talking about that, wanting to make sure we didn't interfere with towns that have robust rental oversight, rental inspections in place. So I don't think we want to duplicate efforts. We just want to, the vast majority of towns don't have that. So if you could let us know how many do. And
Allison, I think it may be already in your materials, not that you would have noticed it, but a list of the towns and what they charge, which helps answer.
Yeah, you're right. In past materials, we do.
Yeah. So I'll try to find that. And this is Wendy. I'll try to find that and send it to you.